Hello, everybody. I'm Michele Shuster, managing partner of Mac Murray and Shuster, and I'm here with my partner, Chris Weger. If you want to take a second to introduce yourself.
Good afternoon, everybody. I am Chris Weger. I am a partner at Mac Murray and Shuster. And while Michele needs no introduction, I will briefly let you know that that I do both work in the compliance and litigation area. So as we're talking today, hopefully I can supplement a few things Michele has to say in the compliance area and add some perspective from the litigation side as well.
Yeah, so to get some housekeeping items out of the way, we do have a Q&A box that's available if you want to ask questions during the webinar. We'll try to get to all those questions during the webinar. If we don't, though, we'll get back to you after the webinar via email if you provide us with your email address. Also, this is being recorded. And lastly, a disclaimer about legal advice. While Chris and I are both attorneys and we do love giving legal advice, today we're providing information, but we are happy to speak to you after the webinar if we can assist you with any of your legal compliance or litigation needs. So with that, Chris, let's get started.
Sure. And I feel that I think the thing to kick off with is the FTC. It seems like everybody's been talking about that the past week or so. And I know, Michele, you've been looking at this closely with the new FTC sweep.
Yeah.
And what the implications are on all aspects of the lead chain, from lead generator to brokers to sellers.
Yeah. And I was out on vacation when this came out, and that is a common occurrence. There's always a major regulatory action that comes out when I'm out of the office for the week. So I think I'm never meant to have vacations. But anyway, so this one, at least this one we anticipated. And what we're talking about is the FTC and the state AG's stop scam calls. Sweep is what they have called it. And there's been a lot of information out there in the press about this over the last several weeks since it's come out. But for those of you that may not have been reading about it, it was a coordinated action between the Federal Trade Commission, the AGs, all 50 of them in the District of Columbia as well, and the FCC, which filed either press releases or they filed actions on or around the time period of the sweep. And what was interesting about this sweep was how all-encompassing it was in the whole ecosystem of telemarketing, as they like to say. The sweep involved actions against lead generators, telemarketers, voice service providers, and so it really hit a broad range of companies. And the point that was trying to be made by this was that these regulators are acting in unison. They are coordinating, they are working together. They are sharing information, and primarily they're doing this through what they've called the anti-robocall task force. And you may have remembered last summer, we provided a lot of information from the meeting that the FTC and the AGs and some of the other industry participants had in DC, where they kicked off the inauguration of this anti-robocall task force. And we knew at that time that it would lead to this kind of unified enforcement among those groups, and also just the sharing of information that we know is happening now. A lot of it is coming from the industry traceback group, which is led by US Telecom, which is the trade association for the carriers. The ITG has visibility into call trends through the carriers, and they are also issuing what they call traceback requests to carriers to find out where calls are originating from. All of the AGs and the FTC and the FCC have standing subpoenas with them, so they are getting the information that the industry traceback group is gathering. And from that coordination, from those records, from the information, and all of the civil investigative demands and subpoenas that have been issued over the last year or so, that was really the culmination of what happened with this Operation Stop Scam Calls. And so, what I think is the takeaway, and Chris, interested to hear from you in this as well, is that the regulators really are looking at a comprehensive approach to regulation. And so, whereas I think companies have been primarily concerned about litigation from class action attorneys, I think now the regulators have really upped the stakes here and have said that they were going to be active participants in this enforcement as well. And, we knew this was coming starting probably about 7 months ago, I had been doing a fireside chat with Lois Greisman, who is the director of marketing practices at the FTC. And during our preparation for that, she had mentioned that she would be talking about from the stage for our presentation that it was the FTC's position that a seller could only get consent directly from the consumer themselves. And so she was mostly pointing to lead forms that have long lists of marketing partners that are hyperlinked to the lead forms, many of which she said were unrelated to whatever the topic of the website was. And she called them, I think, lead farms, I think is what the term was. But, she said that this is the FTC's position. It has always been the FTC's position. And then shortly after that, what we saw was a document that the FTC keeps on their website called Complying with the Telemarketing Sales Rule. It's on ftc.gov. If you Google it, it's very easy to find. It's actually a really helpful document. I always recommend that my clients take a look at it when they're looking at compliance matters around telemarketing, because it gives the FTC's opinion of what the interpretation of the telemarketing sales rule was or is, and it gives practical guidance on what those interpretation means. So it gives real live examples. And so what the FTC did, and this happened in the spring, was they revised their complying with the telemarketing sales rule guidance for pre-recorded messages. And specifically, I can give you the language here. It says, it asks a question and then the FTC provides the answer. So it says, does a consumer's written agreement to receive pre-recorded message calls from a seller permit others, such as the seller's affiliates or marketing partners, to place such calls? And then the FTC responds by saying, no, the TSR requires that the written agreement identify a single specific seller authorized to deliver pre-recorded message. And the authorization does not extend to other sellers such as affiliates, marketing partners, or others. And so, I think that was the FTC throwing down the gauntlet. Lois also warned that there was going to be an enforcement action that would emphasize the position on using marketing partners or extending leads beyond specific identified sellers. And so that's certainly what we had in this sweep. As I said, it really went across the whole ecosystem of the telemarketing world, from lead generators to voice service providers. Anything you want to add, Chris, about this?
No, so I mean, the interesting point that I want to raise, and what we see a lot is that all marketing partners are not created equal, right? We see a lot of variation there. You can have a single lead page that's industry specific, health insurance or home alarm systems, for example, and there may be 2 or 3 providers who are in that exact vertical that are listed on the page, as one example. But at the same time, too, you see other lead paths that could be, kind of on one end of the spectrum, right? Kind of incentivized leads that are unrelated to any specific product being sold. You click on a marketing partners list, and there are 1,000 different disparate companies, none of which are related to each other or what the consumer is requesting. And I guess even beyond that, you can just have a reference to marketing partners, but those are unnamed. Now, when the FTC comes out and they state it has to be a single specific seller, does that put, kind of this gamut that we're talking about, does that put all of them on the same level, or kind of within the FTC's kind of purview and review here? Do you have any insight as to whether those would be treated differently, or are they all the same if it's not one-on-one seller specific?
Yeah, so that's the $1 million question, right? So I can just tell you from my perspective what I have seen. So just going back to the conversation I was having with Lois Greisman and our fireside chat, I mentioned to her, and I'm sure some of you have heard me talk about this before, it's a 2006 staff opinion letter that was put out by the FTC. And it was in response to an attorney from Hudson and Cook that was asking a question about a comparison marketing page that was for mortgage companies. And specifically, it was asking if you could get consent to make telephone calls so that you wouldn't have to scrub against the do not call list for these websites because they didn't know at the time the consumer was providing the information, which one of the mortgage companies would be calling them back. And while the FTC said that a web page like that did not provide an existing business relationship, which would be an exemption from the do not call scrubbing requirements, that the FCC would use their prosecutorial discretion, love that term, their prosecutorial discretion to not bring a cause of action against a company that was following the very specific type of marketing practices that this mortgage or mortgage comparison site was using. So that's good news. Asked Lois that question again. She said, yes, that's not the type of companies that we're looking to go after here. We're worried about I think she again used the word consent farms here. And so that's good news. And while many people think that the TSR does not have a private right of action, it actually does have a private right of action, but it's never used because you're required to have a minimum of $50,000 in damages. And I'm sure there's nobody on this webinar, nor Chris or I, that could come up with a scenario where there were $50,000 worth of damages in order to initiate a private telemarketing sales rule cause of action. But that doesn't prevent the FTC or the state AGs from bringing claims of violations of the TSR for not following what they say is adequate consent collection procedures. And it's interesting. So I don't know what the answer to the question is. All I can say is that probably the chances of the type of risk-based analysis that you had where there's low risk, while it might not be a specific seller to specific consumer, all the way down to the thousands of unrelated marketing partners. I think that we're talking about the ones that are the little risk up there. And this would be a good thing for you to run by your attorney to do a risk-based analysis and also to prepare a defendable position to make sure that if you did get contacted by a regulator that you could defend that. But it is a gradient level of risk. And also, I think that we have found, and I'm sure you in particular with all of the litigation that you've been involved in, it's rarely that type of thing that gets the attention of the regulators. Sure. It's usually something else that's bringing them in to look at it. So you really got to do a whole evaluation. And so that brings us to the FCC.
Yeah. Well, I mean, before we do that, one quick point, I had one parting thought. It's interesting when you talk about the FTC going after kind of every aspect of the ecosystem. What we've seen in this sweep are lead generators being implicated, where traditionally under TSR, TCPA cases, what we see is it's the end caller, it's the seller that's being the target here. But we are seeing the FTC under kind of aiding and abetting theories, or kind of even Section 5 of the FTC, kind of going after lead generators. And kind of anecdotally, one thing I've seen that wherever they are on the gradient of risk, a lot of our clients are recognizing that this is the issue, and kind of one approach that a lot of kind of our clients have taken, which kind of depending on both your risk tolerance and kind of the form of your lead generation practices, what they've been doing is, this has gotten their attention, and what they're doing is they're newly now passing down restrictions on their lead buyers with respect to using pre-recorded messages, because they're worried, right? Because now that this door is being opened up on the lead generation side, that somehow the use of pre-recorded messages, intended or unintended by the lead buyers or ultimate advertisers or seller, could implicate these lead generators. So I just bring that up as one example of what some of our lead generator clients are doing to help insulate themselves out of this new apparent risk. That's not the only answer, but there are a number of ways to address this. It's interesting because historically the concern has always been, the person who's utilizing the seller has that concern where, they're looking back, if they're buying leads from a lead generator or from some other publisher, that there can be this black box where they're worried about, hey, there's some risk here in terms of how this lead is being collected. Now we're seeing the converse being the case a lot of times, where lead generators are looking and saying, hey, I could be opened up to risk now based on what the lead buyers and the sellers are doing here. So it's definitely something that has caught people's attention, and we're taking steps to hopefully mitigate these risks.
Yeah. And this Operation Stop Scam Calls primarily was focused on pre-recorded messages.
Mhm.
So definitely this sweep is something that if you are using pre-recorded messages, you really need to take a look at those campaigns and really make sure that you have all of your compliance buttoned up and that you feel very good about your consent, because that's the target. It's I get the question all the time, Michele, what's a robocall? Where's that defined? And it depends on which regulation you're talking about, and it's not defined. Although the regulators have thrown it out there so much, we know what they mean, but it's not defined in statute or law. And from the FTC perspective, when they're talking about robocalls, they're talking about pre-recorded messages. From the FCC's perspective, when they're talking about robocalls, they're talking about pre-recorded messages or any calls that use an automatic telephone dialing system, because that's what the FCC's TCPA regulates. So, really the foundation of what the FTC and the AGs were looking at with these pre-recorded calls.
Sure.
With this operation.
Before I really cut you off, I think we were starting to talk about where this issue with the lead generation and the use of marketing partners and other forms that has been, I don't know, common, but it's been a practice over the past few years. It's been addressed under the TSR, but it's not only there. TCPA, I'm sure everybody else is aware of over the past few months how the FCC has come out with the notice of proposed rulemaking on what we're talking about is this loophole, the lead generation loophole, quote unquote. And it looks like under the TCPA, there's also questions, and this will go beyond just questions about pre-recorded message in terms of obtaining consent under the TCPA. And this also addresses the use of kind of these multi-seller online lead generation forms.
Yeah. We throw out so many acronyms, and then when I get halfway through, I'm like, gosh, we should probably, for people that might be listening to us for the first time, explain what the acronyms are. But TCPA is Telephone Consumer Protection Act. TSR is Telemarketing Sales Rule. The Telephone Consumer Protection Act obviously is regulated by the FCC, Telemarketing Sales Rule by the FTC. Fundamentally, the laws do the same thing in prohibiting certain types of calls without consent. For the TSR, it's pre-recorded messages or ones to individuals that are on the do not call list. And for the TCPA, it's all of those, but then add in this automatic telephone dialing system, which we're going to give an update on here sometime soon, but or here in a few minutes. But so the FCC, and this is something that was released, gosh, it's probably been 2 months ago. And it was the FCC releasing a notice of proposed rulemaking that, among other things, was just self-described as aimed at closing the lead generation loophole. And the FCC was primarily looking at the types of things that we're talking about with this FTC enforcement action. And that is the use of forms, lead generation forms, to obtain consent for numerous companies. And the FCC is looking at when it published this notice of proposed rulemaking, it's looking at what should the FCC be doing to provide more clarity on how you can provide consent for multiple sellers in one lead generation form. And so that's really what that rulemaking is looking at. We submitted comments on behalf of PACE in that rulemaking. And what's interesting about the way the FCC is approaching this is they're looking at whether the marketing partners, a list of other sellers, is logically and topically related to whatever the website is about. So if the website's about home improvement or things like that, then if you're looking at more than one seller to get consent for, then are they logically and topically related to this topic of home improvement? And so that's what they sought comments on. And they also threw out a proposed rule that brought out that logically and topically related terminology. And so they're going a little bit farther than what the FTC is, which is not really looking at the content of the website or the lead form or even so much how many marketing partners. But in what the FCC had thrown out as a rule is that that any sellers that were purporting to get consent from that lead form would have to be listed on the same page that the seller was getting consent to make subsequent phone calls to. And so, in comments that we filed, we pointed out that that's probably not extremely helpful if it is take at that mortgage comparison website where there could be dozens of different mortgage companies that might be out there because they were looking for one that would specifically fit the needs of a consumer as they were describing their needs. And so it'd be interesting to see where the FCC goes with this logically and topically related and with their rulemaking. But just one last interesting point. I'm feeling very talkative today, Chris. But one last interesting point is, I went back after the FTC sweep and looked at what the AGs had filed in the FCC notice of proposed rulemaking around closing the lead generation loophole. And what the AG said that filed this comment is that there was no need for the FCC to issue an additional rule because the TCPA already required one consumer to one seller consent for it to be valid consent. They said that this lead generation loophole was just a created figment of the imagination of the lead generation industry, and that it wasn't necessary. So that is an interesting approach that the AGs who would be enforcing the TCPA for their states have taken on the TCPA. And so while we are specifically talking about the FTC here, you kind of have to go back and look and say, well, you know what, if the AGs are going to take this position and I'm at risk of an AG enforcement, then maybe for the TCPA, that's something I need to be concerned about as well.
Right. And what's interesting about the TCPA is that there undoubtedly, as anybody in the industry knows, there is a private right of action, and the vast majority of actions are these class actions. So, how the FCC comes out with its ultimate rulemaking, I'm sure will have a huge impact in terms of what types of lawsuits that we're seeing. It sounds like the FTC and it's lost an acronym soup right now, right? The FCC right now, while it appears that they are taking somewhat of a middle ground, they're not going as far as the FTC is with this Operation Stop
Scam Calls.
Yeah, say that 3 times fast.
Right, yes.
They're taking that middle ground, but I mean, it will definitely be interesting where that comes out and what effect that will have, because we know that the threat of a TCPA class action lawsuit is a real wake up call or deterrent there. So kind of how they come out will be important. The Attorney General, it's interesting to me that they're coming out to take that position, because when we see litigation, the TCPA has been heavily litigated for many, many, many years now. And, that's not a point that has really been raised in litigation or that courts have upheld. So, these state AGs are, it seems to me, kind of taking a position that hasn't been consistent with where we are in the litigation. But as we all know, that won't stop them from bringing in action and trying to push their viewpoint.
Yeah, I wonder when the first motion will be submitted by the plaintiff's bar citing the AG's comments. Although they don't have the authority to interpret the TCPA, only the FCC does in courts. It's interesting. And I bet we will see it.
Oh, of course.
I bet we will see it. All right, so I've been getting a lot of questions, and I know you have too, about where we are with the definition of automatic telephone dialing system that's in the TCPA. And as you probably know, the TCPA prohibits the use of an automatic telephone dialing system to call cell phones without the prior express written consent of the consumer, or the called party, I should say. If it's a marketing call, if it's a non-marketing call, more of an informational type call, then it just requires prior express consent. But the important thing is the definition of an automatic telephone dialing system is so critical for this TCPA, for the TCPA litigation, and for the class actions that the plaintiff's bar is bringing. And so we had 2 interesting developments over the last couple of weeks that Chris and I thought were worth talking about. One was a case out of Colorado, Shearer versus, I think it's FTP is the name of the defendant in that, but it was in the Colorado Circuit Court, and the court was ruling on a motion to dismiss that had been filed. Let's hope I don't need my glasses. a motion to dismiss that had been filed by the defendant, and the defendant said that we were not using an automatic telephone dialing system as it's been defined by the Supreme Court, which all courts, and what we've seen out there is that under the Supreme Court definition, under Facebook versus Dugan, you have to be using a random or a sequential, a random or sequentially generated telephone number system, a system to randomly or sequentially generate telephone numbers. There we go. And then to be either storing those and then dialing them. So it's really focused on the random and sequential number generation of the telephone number.
Which means that if you have a targeted campaign, then necessarily wouldn't be randomly sequentially generated numbers, because you're identifying who you want to call. It really is dealing with these blast calls and texts that, technologically speaking, nobody probably engages anymore.
Yeah.
But and that's been our reading, where the Supreme Court's Facebook decision generally stated that, the actual phone campaign that you're engaged in, if it's a targeted campaign, then that's outside the purview of an ATDS, and that's a matter that can and should be decided on the pleadings, if a defendant or if the pleadings demonstrate that this is a targeted campaign.
Which is really important, because if you can't get rid of one of these class actions at the pleading stage, then it becomes very expensive to defend these class actions. And the risk is so high when you're talking about 500 to 1,500 per call,
Sure.
and these
Yep.
involve hundreds of thousands of calls usually. So risk is very high. So what the Colorado Circuit Court held was that the definition that was provided and the explanation that was provided by the Supreme Court was not all that clear, and it referenced this footnote 7, which actually was referring to a brief that we filed on behalf of PACE, and it was specifically addressing an issue that the Supreme Court was looking at as to what it meant in the definition of ATDS to have to store or to produce telephone numbers using a random or sequential number generator. And so we pointed to a patent that showed where there was a predictive dialer that could randomly and sequentially generate numbers, and it could either store those for later use or it could dial those immediately. And so the point being that that wasn't a superfluous word store, that it meant something, and it was specific to the type of dialing systems that it was trying, that the TCPA was targeted towards. But it's led to some confusion based on the Supreme Court pointing out that this dialer could store numbers. And so in this Shearer case in Colorado, the court again looked at the definition of ATDS, and it said that the courts were reading it too narrowly, and it believed that if a random or sequential number generator was used to create an index, it would index the list of telephone numbers from pre-populated list, as Chris was describing, then that was the type of random or sequential number generation that was also prohibited by the TCPA, because the type of dialing that's happening nowadays is the type of dialing that's from a pre-populated list. No one is dialing randomly generated or sequentially generated telephone numbers anymore. And if you don't take that position, then the TCPA has no weight.
Right.
Which is, I don't know, an interesting approach for a court
Right.
to take.
Well, and I always look at these things from some sort of modicum of what makes sense, and how numbers are stored in an index on a system that has no effect whatsoever on who's being called, how they're being called, anything along those lines. This is creating, a technical distinction that has no practical effect. But I guess at the end of the day, the practical effect is that, after Facebook, we saw almost universal decisions that drew this distinction that was an easily drawn line, which was, if you have a targeted list, then generally speaking, that's going to fall outside of the definition of an ATDS. This case now is an outlier. There still is, still out there, 98% of the cases are cutting the other way, but we do now have a decision that's opening the door. And functionally what it does is, by taking that out of the pleading stage, that creates a factual, expert intensive issue, which, heaven forbid this gain traction, but that basically would take all the teeth out of all the progress that we've seen since Facebook, and basically bring all this back in and stick calling parties with with this immense burden to show in discovery whether or not their dialer, fits under this new distinction of an ATDS.
Yeah, this decision just came out, I think it was last week, and it is FPT operating company. So if you're listening to this webinar, I hope you are appealing this because this definitely needs to be appealed. Otherwise, the trial courts in Colorado are required to follow this precedent. But we bring that up because another thing happened at the same time, and many of you out there have probably been following the Brickman versus Facebook case that's out of the Ninth Circuit. And the Ninth Circuit has been a very activist circuit when it comes to defining ATDS and other TCPA questions. And so this Brickman versus Facebook case had been decided by the Ninth Circuit in California as the definition of an ATDS is as it was held in Facebook versus Dugan, and as we have described, that it does not include a system that uses a list from a pre-populated or phone numbers from a pre-populated list. But the attorneys who lost in that case on the Ninth Circuit appeal have now filed a writ of certiorari with the Supreme Court. So they're asking the Supreme Court to come in and take a look at that decision and to have them again look at the definition of ATDS and what they actually meant in footnote 7. So we bring that just because it probably means that for the dialers that you're using, you should probably have your attorney take a look at them again, make sure that this indexing is not an option. Plus, there are some state, what they call mini TCPAs that also look at the automatic dialing of telephone numbers, and the generation of those using an indexing system could bring them into that definition. So
the case law is trending in our favor, and hopefully, we've got our fingers crossed that the Supreme Court does weigh in on this, that the Facebook decision was unanimously decided. So I think the intention, despite maybe some uncertainty, whether actual or invented, about what the Facebook decision said, we're hopeful that the Supreme Court will step in and resolve any questions as to that, and hopefully help put this issue to bed. But I feel the TCPA, in my career, it's every step there's a decision. You think this is the end of the plaintiff's bar, and somehow they find a way. I guess that statutory damage award, leaves a lot of incentives to find some approaches here to keep this going.
Yeah. So what other kind of litigation trends are you seeing out there?
Sure.
Chris?
Yeah. Really, I kind of break down litigation demands kind of in two buckets. The one is the class action. We really are seeing, with the exception to some of these outlier cases, since the universal movement on Facebook is, really there are not any meaningful kind of continued actions on the ATDS front, which used to make up the vast majority of claims. What we really do see kind of the fallback now, which is really the low-hanging fruit for the plaintiff's bar, is pre-recorded voice. When they're seeing pre-recorded voice use, and that includes also ringless voicemail drop, soundboard technology, they really are using that. Whenever they see that, they will bring a claim. And I'm sure anybody who's dealt with a TCPA lawsuit or demand knows when we do have valid consent, when they see pre-recorded voice, a lot of times they see low-hanging fruit. We come back, we show what appears to be airtight evidence of valid consent, but they come back, they deny it, and usually that becomes a litigation issue. So definitely, any time that we're seeing pre-recorded voice use, in addition to the FTC and FCC issues we talked about before, that is also creating an easy target on the litigation side. A lot of times we're seeing now another move towards DNC claims, both calls with DNC registry as well as internal do not call requests. With that, what's interesting, with the DNC, as we know that the exemption to a DNC registry claim can fall under either consent or an existing EBR, an established business relationship. So a lot of, again, that falls back, just like we've seen before, is these lead generation forms to show that someone actually has provided that, I say EBR, I guess that splits into two. We're talking about inquiry EBRs. When we have an existing business relationship, a former customer, such as a win-back campaign, that's a different bucket. But again, a lot of this is falling back on providing evidence of consent for a lot of these calls. Interestingly, we're also seeing it's frequently overlooked, but when we have the internal do not call, the specific regulation under the TCPA is that businesses have to have policies and procedures in order to honor internal do not call requests. Also in there are requirements of having internal policies and procedures about call disclosures, and other aspects, and more technical aspects of the call, training, and all that. And what we're seeing now, even as plaintiffs are trying to bring claims for failure to disclose, there is a requirement there that a caller has to provide a name and contact information in association with an outbound telemarketing call. And we're seeing standalone lawsuits where the only alleged violation is a failure to disclose there. So we are definitely seeing some kind of testing of the waters there. So it's important to not only to have the kind of policies and procedures in place about honoring do not calls, we have to look at all these other requirements that are there. There's about an 8-point list there to ensure that you're hitting those, because even if you are honoring every other aspect, something as small as failing to identify the caller at the beginning of a call could give rise to a TCPA class action. In addition to that, again, with the kind of the limitation on the ATDS, we are seeing kind of other novel claims. Just one example that that I know offhand that we're dealing with is a plaintiff's attorney now, a very well-known one who's probably probably many of you are familiar with. Has a new theory that they're pressing, is that when you have a prior business relationship, which would be an EBR under the TCPA that allows you to do win-back calls, right? You have a former customer, you have that 18-month window. That this new theory is that when a customer terminates a business relationship, they also terminate the EBR, so that any win-back call would then be a violation of the TCPA. That's a legal question where we're clearly, we think that the 20-year history of the do not call regulations are clear on that, but that just goes to show you that even when otherwise kind of everything is buttoned up, that doesn't stop these kind of novel theories, novel claims. We're always seeing people kind of pushing the boundaries, testing the waters here in terms of what could potentially bring a claim.
What's so interesting about that too is and it's hard to believe it's been 20 years. You just said that. I know 2003 is 20 years.
Yep.
So I was in the AG's office in 2003 when we were passing these do not call laws, and the specific scenarios we were concerned about with the existing business relationship was so that you could make those telephone calls.
Right.
So there could be continued telephone calls at the end of a relationship. So it's interesting to see how creative the class action bar becomes with these types of things. But I bet there's a lot of legislative history probably around that when looking at those types of things.
Yeah, less than you think, because it's not a theory in 20 years it's really been raised, so it really hasn't been addressed much, because I think
not that legislative history matters, but
and in my unbiased opinion, it's not addressed because everybody understood that our understanding is correct. But
that's right.
And so aside from class actions, what our clients deal with a lot are these kind of individual claimants that are coming up. And over the past few years, I've only seen this increase more and more, where whenever you're doing outbound calling, these demands come in. We see these same form letters over and over again. People are usually they're small dollar demands that are coming in. And really what we're seeing here is, these claims aren't necessarily tethered to a valid legal claim. I see so many of these are still tied towards ATDS claims, which, as we talked about with Facebook, these claims are largely unsustainable. But when you're dealing with these individual claimants, it does not faze them, and any evidence that you kind of provide back doesn't work, in order just to largely to get them to go away. So it's kind of, they found this sweet spot, right, where it's kind of, they demand a small enough dollar amount where it has to make our clients think seriously as to whether or not just as a nuisance value, it's worth going away. Because a lot of times the end result, the threat is typically not necessarily a class action, but you've got these small claims court somewhere in some remote part of the country, then the client has to worry about defending, which then becomes an onerous process. So, that is, becoming a difficulty. But I can say with these, given that, having all your ducks in a row from a pure compliance standpoint doesn't necessarily make these things go away. What we see is, as the proliferation of these increase, it is really a small pool of people where this is coming from. And kind of the one piece of advice I do give clients is there are a number of products out there which are litigator scrubs, where you can run your calling lists against a database that vendors provide of known litigators or known demandants. And we see that this can have a profound effect on reducing these kind of nuisance claims. That this is never a substitute, right, for actual compliance. But when we look at these frequent flyers, I feel that it can be an effective means to kind of help minimize those claims. And, I've had instances where clients, where they normally use these, they've had a list and we work with them, we're confident in their compliance, through some sort of mistake or oversight, they run a call list that hasn't been scrubbed through these lists. And whereas they can go months or years without receiving a demand, the failure to run one of these things, I mean, I've seen where they get eight demands within a week based on that. So just
because these frequent flyers see these lists.
Yep,
And
exactly.
I know we've told stories about these in the past, so we won't go into it again, but yeah. And DNC.com is an excellent example of one of those no litigator scrubs. I think Compliance Point probably has one as well, or Possible Now probably.
Yeah, exactly.
More likely, but yeah, interesting. It's
Yep.
interesting.
Yeah. So with all this, it's always TCPA, like I mentioned before, it's kind of, one step forward, two steps back. We see great progress, but there's always incentives out there for, for people to come forward, on both meritorious and dubious basis. So, we're always working with our clients to, I'm lucky where I straddle the line there on compliance and litigation. So kind of working to stay compliant, but, whenever you're engaged in outbound telemarketing, there's always that risk of of a demand or litigation coming your way.
Yeah, unfortunately so, but having that defendable position is just so critical. And we find the companies that do that ounce of prevention. They've definitely saved from the pound of cure, and they do that in the
Right.
form of these defendable positions.
Well, and definitely, and that goes to, while generally speaking, the TCPA is a strict liability statute, kind of the defendable position actually is all the more important when we talk about these do not call and these policy violations we talked about. There actually is a kind of a bona fide error safe harbor where there actually is a defense where if there is an inadvertent violation, if you show that you have written policies and procedures in place that are robust, then a lot of times that can be a defense that even heaven forbid there is a violation. If you do have those policies and have the foresight to have those in place, that is something that you can rely on as a defense that can absolve you of liability, even in the face of an inadvertent violation.
Yeah, and we're seeing that in the regulator subpoenas that have been issued recently, and the civil investigative demands, either from the AGs or FTC or FCC, is that they're requesting copies of those policies. And especially for the voice service providers or intermediate carriers, because there have been so many requirements that have come out from the FCC recently about your policies and procedures that you need to have in place for robocall mitigation. That's another one of those areas where it's just really critically important to have those in place before you start any campaigns, because otherwise that does become the focus. And I can tell you the response the regulators have when they receive information from the companies that do have those in place ahead of time, very different than those that do not, which we're seeing less and less, I should say. Well, there was one interesting thing that I wanted to bring up that was in our legislative monitoring in this past month, and it's in Maine, which I found out, and I probably should have known this already. Maine only has one area code, 703, and Maine is becoming very protective of their area code, and has, as a result, passed a new rule through their Public Utilities Commission about the use of Maine area codes and the acquisition by voice service providers or carriers of the Maine area code 703. And they're now requiring that you register with the PUC if you are going to be using those Maine area codes. And as well as registering, they're also looking to see if you'd be required to also participate in the main, I think it's called the Universal Fund, Universal Services Fund, like on the federal level as well. And that you may need to collect for that as well if you're engaging in certain types of calls. So if you are marking into Maine and using the 703 area code, I highly recommend that you take a look at this new regulation. You can go to Maine's Public Utility Commission's webpage, and you'll find in their news release a copy of this new regulation. So I thought it important to get that out there. All right, so let's see, what other kind of interesting topics do we have to talk about here? AI, do we want to talk about that at all? We get a lot of questions about AI and SMS. I know we got some questions about those.
Sure.
Not, those is two separate topics, SMS and AI. So what are you seeing in the AI world out there?
Well, what we see a lot, and we do have a couple of written questions that I've got here that address this a little bit, are kind of, AI, companies are using generative AI, both, I think, or looking to it or using it both in the kind of in the texting space as well as the voice space with consumers. And there have been, I believe, so some recent decisions or recent guidance as to each. I guess it's a mixed bag, right? Where with respect to voice, my understanding now is that AI generated voice is being treated as a pre-recorded message.
Yeah. And the TCPA speaks specifically to an artificial or pre-recorded voice. So definitely under the TCPA. The FTC has interpreted the telemarketing sales rule is also applying to the artificial or pre-recorded voices. So I think if you're using AI, as you're putting together, if you're using AI to interact with consumers over the telephone for outbound calls, then the best practice and I would say requirements is to make sure that you're complying with those pre-recorded message laws and requirements in the TCPA, the TSR, and I would do it on the state level as well.
Exactly.
Otherwise, I think you're at risk for a lawsuit or regulatory action there.
So we're putting an AI generated voice in the same category as soundboard, right?
Yeah, yes, we are. We are definitely putting it there.
But the flip side of that is with outbound text messages, where we've got an automated procedure to generate that. We have had positive case law come out recently that has said that the generated text in that manner does not constitute a pre-recorded message. And that follows, I think, a general line of cases that has historically found that the kind of not to use a pejorative word, but kind of canned text messages,
chat boxes.
Yes, chat boxes, standardized messages, those generally do not fit within there. So that kind of fits along those lines. And kind of one interesting side, while we're talking about AI, I've seen on a couple of instances now talking about these individual demandants that come in, where I've actually had people let me know that they have used Chat GPT to draft these TCPA demand letters. And truth be told, when I got them, nothing jumped out at me as and maybe that's a testament to Chat GPT, or maybe a reflection on the other demand letters we get from these claimants. But I didn't realize it until I was told that. It's funny that there was one where the client wanted me to respond to each of these, and I would provide a thoughtful response, explaining why your allegations don't constitute TCPA violation. Within an hour, I would get a 2-page letter back, and this back and forth one happened about 3 times. Cut to the chase, I ended up talking to the guy who's a perfectly pleasant guy, and in that conversation he goes, I use Chat GPT to draft those letters. I'm like, oh well.
How does it feel about having AI on the other side of your cases now?
That's scary.
Actually, I think that you will be more right than they will be. Always. 100%.
I agree 100%. And so going back to the questions, one question that we had was any input on predictive dialing. I think that's something largely we talked about with the Shear and Brickman cases, about how the cases of generally the distinction now is really falling more along the lines of are you calling from a pre-populated list, but again, with the cases there still is some uncertainty out there. And we did have, when you say text, we've had a number of questions about how these recent decisions are specifically affecting SMS and SMS texting policies.
Yeah. And so, with SMS, I think you've already answered the question that if you're using the AI, it's the courts have already ruled that that's not treated as a pre-recorded message. So that is good news. Let's see, we have a new one that came in here asking in response to Chris talking about the disclosures that the TCPA requires for telephone calls. And one of those disclosures is the telephone number or address of the party that's calling. Do we think that there's really a private right of action that extends to those disclosures in the TCPA? And the answer would be yes. And I will tell you that, I've worked with some companies, even as, we've done audits for them, that as they are recording for quality assurance, the telephone calls that their agents are making, if they get hung up on before they're able to give that disclosure, they'll make it on the recording before they hang up, provide their telephone number that would be able to accept a do not call request so that they can show that they have that in every call that they place. Well, that might be a little excessive if they've already hung up. It would probably be a best practice. With these disclosure requirements, it's not like the other disclosure requirements that need to be made immediately, those being the name of the person calling, who they're calling on behalf of, and the purpose of the telephone call. Those need to be made immediately upon the telephone call. And then some states have other requirements, including, no rebuttal requirements and permission to continue. And New York now requiring that you disclose that the called party can make a do not call request at the beginning of that telephone call. So, the disclosure for the address or telephone number is different than those initial disclosures required. It can just be made at any point during the telephone call. But yes, that's something that should be in your script. And I can't over emphasize how important that is, that your script have that disclosure, because when you're asked to produce a script either in discovery or to a regulator, and your script doesn't comply with these disclosure requirements, then that is going to be a huge red flag. And they're going to want to assert that every call therefore was made in violation because it's not in the script.
Yeah, and kind of piggybacking that, the kind of the nerdy litigation answer as well as it's actually, when you say time will tell, that on the question, that is true. So there are a number of cases that have held that on its own, a failure to disclose claim is sufficient to maintain an action. There are other cases, and I think the argument we would make is that in order for a plaintiff to have standing to bring such a claim, because this is all tied to the internal do not call policies and procedures, is that there has to be an internal do not call request that was not honored in order to provide standing to bring these other failure to disclose claims. That's the position we would take. It's not settled. There's other courts that have, what they've talked about is, for example, disclosing the phone number to be contacted or your name. They state the purpose of that requirement is that it needs to allow a consumer to be able to identify who it is to be calling them so that they can submit a do not call request. And courts have stated that failure to provide that information is sufficient in itself in order to constitute a violation with a redressable injury that could allow someone to maintain a claim. So the jury's out there. I saw one case, I think it was settled early, so there was no actual decision on it or even motions filed, but it dealt with a large national retailer that had a text messaging campaign. And, as is a good practice, they began their text message with their identity, like the name of the store, and then they had the substantive message. And a well-known TCPA plaintiff's attorney brought a TCPA lawsuit because he stated that the text messages failed to provide a phone number and an address for the seller, which, as we all know, that you can't do that with the text message. Exactly. But those cases are out there. That the case was, it didn't proceed to a level where there were any briefing or decisions on it. But again, with all these novel ideas, they're testing the waters, and they're trying to find a way.
Yes. Let's see. Is there anything else? I guess just one last update here on the privacy front that Texas and Oklahoma have passed state privacy laws. So we're seeing more states pass those laws in the absence of a federal privacy law, which we're still really hopeful will happen because, the difficulty in complying with all of these individual state privacy laws is really becoming complex. Actually, I saw in Law 360 this morning that big law firms are asking that law schools start training
Saw that.
law students on privacy regulations. It's not even a course that's provided in state privacy regulations, I should say, not really a course that's being provided in most law schools. So I would second that and request that they please start training the law students. And I think that probably brings us to the end. Do we have any more questions?
I'll give you guys a minute or two to submit anything else, or
Yeah. In the meantime, this is the first time we're doing a webinar in this space. Feel free to send comments about our tree in the background. It's a Buckeye tree, in case anybody's wondering. We are in Columbus, Ohio. It does look like something more appropriate, probably from our cannabis and hemp practice area.
but it's a Buckeye tree.
It's a Buckeye tree. Yeah, I don't know that I'm a big fan, so like it or not. All right, so when somebody asked if we could share this recording, and yes, we will be sharing this recording. It will be on our website probably within a day or on Monday. That's mslawgroup.com. I highly recommend you subscribe to our blog to keep you current on all of these developments that Chris and I are talking about, which literally are happening on a daily basis. So I encourage you to do that. And with that, I think we're at the end. Thank you all for sharing your afternoon or late mornings with us. And we look forward to seeing you on the next webinar. Thanks, Chris. It's been great doing this with you today.
It was fun.
Have a good day.